Testing, testing. I want to make sure this works fine. Just a second. I also want to get onto the proper. Okay, there it is. Alright. I am connected, and now it's time to start looking at the notes. These notes were prepared by a really friendly person who loves the Constitution. And they're not specific, they're kind of specifically for me, but also they could be used for anybody. Alright, let's start out. There's a lot to read here. Let me just show quick. Alright, I'm just gonna scan, blah 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 blah. Look at all that. So I don't think I'll finish it all. Look at all that, it's just bottom. It's a lot. So let's get started. This is my trial. It could be your trial in the future. But right now it's my trial. Resisting an officer, and that's under 14108. Louisiana Revised Statute. You will need to subpoena all witnesses. The clerk of court will provide you with the subpoena. The FBI is closing in on my bodies. I should have a chat, actually. Let me just take a look at something. And isn't there... Okay. Alright, I got the chats, but it's kind of... Alright, it's kind of... I don't know. Maybe just straight over here, because I don't want to... Okay, how about that? Chat's there. Just shrink. So it only show... Oh, really? Maybe... Okay, maybe this? Alright, so now we're in... I'm just going to focus on what I'm reading here. I'll peek at chat every so often. Alright, you will provide subpoena all witnesses. The clerk of courts will provide you a subpoena upon your request. You will need to serve them directly to the police, to any commander or clerk, and do not need to tell them you are there to serve subpoenas. They will ignore you. Records who you serve there, in fact, video it, and to Miss Piggy directly. Do not let them tell you that they will have all witnesses there if they are not there and you did not subpoena them. Then it's subpoena them. It's your problem. They will pull all kinds of tricks. I don't know who's going to show up on Monday. Alright. We got 4 subpoenas, the 3 officers and a librarian. And I also asked for the police dispatcher too. So I just throw that in there. Let's see, watching from UK. UK is kind of out of the jurisdiction. You're safe, you're in a safer jurisdiction. Let's see, make requests to the open court prior to trial to have all witnesses be sequestered. That's pretty important. Basic trial information. What is the order of events in the courtroom? Each state, and oh wait a second, let's see, good luck. Okay, do they have Westlaw or Lexus? I'm going to call the cops and see if they can take PayPal. Okay. The judge, clerk, or bailiff will call your case. In some courts, a mediator might first talk to you. Will there be a mediator on Monday? Is it Monday mediator day? And then with the other party to see if you might be able to reach an agreement without trial. In a criminal case, or in other types of formal or more complicated cases, the judge might ask the parties to give opening statements. What are the chances of that? This is pretty informal. This is your chance to talk about what evidence you will show at your trial, and how you want the judge or jury to rule based on that evidence. In less formal proceedings, it's just the bailiff or clerk will swear you and the other party in by asking you both to state your names and to swear or affirm. So, will it be less formal? Because the chances of them swearing in the prosecutor sound kind of low to me. The party that filed the first court papers, usually called the complaint or the petition, is considered the plaintiff. The plaintiff will tell his side of the story first. This includes the party's testimony, calling any witnesses they may have, and entering any evidence that she has. We have more detailed information about this process. Okay. The other party or his lawyer may ask you and your witnesses questions as part of cross-examination, which you must first answer truthfully. You may have the right to object to certain questions that the other party asks. If your witness testimony was damaged during cross-examination, you may be able to ask clarifying questions during redirect. The judge might also ask questions to you or other witnesses. Next, the other party, let's see, the other, Stanley, so we got two, are you brothers? Seismansky. Next, the other party, who will usually be known as the defendant or respondent, will be allowed to present their case. They can testify and tell their side of what happened, call witnesses, and enter their evidence. It may be different from yours. The same principles apply as mentioned earlier about the right to cross-examine questions and make objections during the abuser's testimony, if legally appropriate. The judge might ask for closing statements or not, depending on the type of court. And this is an informal court. Closing statements are your chance to sum up the evidence and ask the judge again for a specific decision. The judge will make a decision after hearing both sides and considering the evidence. The judge may make the decision right away, that's what I expect. I would expect an immediate decision. He's my judge will be like, before the trial, he'd be like, I already come to my decision, but we'll go through with the trial anyway, and then I'll let you know what it is. He could even go so far as to write his decision on a piece of paper before the trial begins, and then read that piece of paper after the trial is done, because he's already made his decision. If your case is no restraining order here. If so, then make sure you get a cop. Okay. Be on time. Have your witnesses there and ready, and serve them some chicken and drinks. Have your evidence ready. And if you have subpoenaed witnesses or documents and they are not in court, you should inform the judge. So if Officer Miller is not there, I have to point that out to the judge. Dress okay. Speak directly to judge. He should understand if you feel nervous. Do not speak or argue with the abuser. Although it may be upsetting to hear the abuser say things that are untrue, Officer Davis, you should have the opportunity to tell your story directly. Well, I'm not telling my story. Always address the judge as your honor. Be prepared to spend all day in court. There may be hearings before yours. If they have children, try to find someone to take care of them. If the abuser comes to court with a lawyer and you do not have a lawyer, ask the judge for a continuance. The police have come to court with a lawyer. I do not have a lawyer. Judge Owsley said that the lawyer has to ask for a continuance. I wonder if I could ask for that continuance. While you are waiting to be called, it is your right to move seats if the abuser sits next to you. How do I protest being part of this trial without a lawyer? Tell the bailiff or any sheriff, police, or security guard if you are afraid for your safety. Oh yeah, they're the ones I go right to. Stand when the judge enters and sit when the judge asks you to. Try to remain calm, but it's okay if you show emotion. Take deep breaths if you feel yourself getting tense. Always tell the truth. If you don't understand a question, just say so. Don't answer a question you don't understand. If you don't know the answer to a question, just say so. Remember, you know your story better than anyone. You are the expert. Don't let the abuser or judge throw you off. And they do. You could say that. Prepare for the possibility that you might lose and need to file an appeal. Why would I enter evidence in court? The only way a judge can decide a court case is based on the evidence the parties present during the case. In many cases, the evidence that a judge has is mostly testimony from the witnesses. However, there are also other kinds of evidence that you may be able to show to the judge to help prove your case. Additional evidence can be especially important. Let me just check something. And, okay. Okay. Evidence going to lie. If the other party is going to lie or tell a different version of what happened than you are, you need that evidence. When there is conflicting testimony, the judge has to decide who's telling the truth. And there's really no controversy about who's telling the truth when it's all on video. The important stuff is on video. The judge will often look to other evidence and witnesses to decide which party is telling the truth. If you have a case that involves domestic violence, having evidence to present you that corroborates your version of the events can be especially important. Many survivors of domestic violence face disbelieving judges who are quick to accept the abuser's efforts to explain away the violent incidents or behavior. Some abusers even claim that the violence did not happen at all and that the survivor is making up allegations to try to get an advantage. Okay, this is all well and good, but this isn't what I need. What evidence can I show to the judge? You can give almost anything to the court as evidence as long as it is relevant to the case and it does not violate one of the rules of evidence. What are the rules of evidence? I don't quite know that. I don't have time to look. For example, you generally cannot give in a letter that someone wrote for your trial or tell a judge something that someone else said due to the rule against hearsay. The most common types of evidence are testimonial, expert, physical, documentary, that's mine for the videos, demonstrative, might not easily be understood without some visual assistance. So, when describing why you had to use physical force in self-defense, you might draw out the layout of the house and indicate where the parties were standing to show why you could not escape. Does testimony count as evidence? It's a kind of evidence. Yeah, I really could go for a continuance. I mean, what are the chances I can ask for a continuance on trial day? I'm interested in doing that. Testimony, and it is often the only evidence that a judge has when deciding a case. When you are under oath in court and you are testifying to the judge, what you say is considered to be truthful unless it is somehow challenged by the other party. If the other party can show the judge that you aren't telling the truth through testimony, they can rebut your testimony. Then the judge has to make a decision on who they think is being more truthful. Who's being more truthful? How do I introduce a witness? Introducing a witness is referring to as calling your witness. However, there are a few things to think about before you call a witness. First, you need to know what your witness has to say and whether it is helpful to your case. Then you need to find out if the witness is willing to testify in court. I don't know. I just call them to my trial. I don't even know if they'll talk. Usually cops, you can expect, would talk. Many people are happy to talk about a situation one-on-one, but don't want to testify in court. If a witness is not willing to testify, you might have to get a subpoena. A subpoena is a court order that makes a person come. Once you know who your witness will be, you might have to tell the other side. This often happens during discovery with a witness list. Depending on the state's laws and the type of court case you are in, some courts will allow you to call witnesses without a list. Make sure to let your witness know when to come to court. Your witnesses might have to wait outside of the courtroom until it is their turn to testify. The reason they have to wait in the hall, it's sequestering. Although the process might be different, you let the judge know who it is that you want to call to come and testify. Alright, and the court officer generally go into the waiting room to alert the witness. The person can then enter the courtroom. They be sworn in. Once your witness is seated in the witness chair, I can begin to question them. How do I question a witness? You can start questioning your witness one at a time by asking them their name and asking them some background information, like how they know the parties. How do you know me? You will then have to get into asking questions about the event they witnessed, and that's when I play my body cam and ask them if they've seen this body cam before. If this is the body cam footage that they took on that day, or any other issue they are there to testify about. It is best if you can prepare with your witnesses beforehand so you know what they will testify about. Wow, that would be nice, huh? That's why I tried to do the whatever it's called, documentarium thing, to sequester the deposition. I'm doing a deposition. I tried to do the deposition, but Judge Owsley said that you don't do depositions because it's doing the trial twice. When you question your own witnesses, this is called direct. On direct, you will usually only be allowed to ask open-ended questions that do not lead your witness, and you will only be allowed to ask open-ended questions. Leading questions where you suggest the answer to the question are not allowed. Here are some good and bad examples of direct. Open-ended. Leading. What color is the sky? That's a good one. The sky is blue, isn't it? That's a bad question. Could you tell the court what you saw? That's a good question. You saw the respondent abuse me on January 15th, didn't you? That's a bad question. For each new topic that you question your witness about, you will need to establish how the witness knows the answer. For each topic that you question your witness about, you'll need to establish how does this witness know. Let's say you want to ask the question, could you please tell the court what you saw on January 15th? Alright, you must first ask questions that help establish how the witness knows that anything happened at all. Were you alive and breathing on January 15th? You want to lay the foundation. This could include questions such as, where were you on January 15th? Was anybody with you? Well, for me, it was January 22nd. So I should change that, right? Where were you on January 22nd? Who was with you on January 22nd? Do you remember what happened that day at noon? And then after you laid this foundation, you can ask the important question. Could you please tell the court what you saw on January 15th? After you finish asking your witness questions, the other side will have a chance to ask them questions, which is cross-examination. Note, when your witnesses are testifying, your witnesses can only testify as to events that they have personal knowledge of. Alright, they are not allowed to testify about things they have heard secondhand. That's objection hearsay. When I testify, who will question me? When you are testifying, you do not need to ask yourself questions. Instead, you can say what happened in story form, or the judge may ask you questions. Remember to include information like the time and day that an instance of abuse happened, where it actually happened, and who was there and what happened. So I'm not testifying. I have to see, that's the thing. It's like, if I don't testify, that takes pressure off of me, so I can focus on the cross-examination more. Cross-examining a witness, that's what you got to do when you're pro se. It's like, when you're pro se, pro se probably means that you should not be testifying. You should be focusing on the other stuff, because trying to do it all is too much. Cross-examining a witness can be very difficult, even for lawyers who have spent a lot of time in court. The purpose of cross-exam is to create doubt about the truthfulness of the witness's testimony, especially as it applies to the incidents that are at issue in the case. Cross-examination questions are usually the opposite of direct examination questions. I'm going to get a drink here. Alright, I might have to get a drink in my trial, and they're probably going to yell at me for drinking. In a direct examination, you have to ask the witness open-ended questions that allow them to fully explain their answer. A cross-examination question should be very pointed and requires only a one-word answer, yes or no. Questions, the witness is hostile. We got to establish a hostile witness. They have established themselves on video, of course. The questions that you ask on cross-examination have to be related in some way to the issues that the witness talked about during direct examination. You can use cross-examination to point out inconsistencies in the witness's story. By highlighting testimony that does not add up, you can cast a light of doubt on everything that the witness has said. Here is an example of this type of cross-examination line of questioning, where you first confirm what the witness said on direct and point out inconsistencies. Didn't you testify that you saw me with my husband at the park on Saturday, and that he did not get hit, and that he did not hit me? Yes, that's what I said. And you said that you took the Blue Line bus to get to the park that day. Yes, that's true. Isn't it true that the Blue Line bus does not run on weekends? Yes, it only runs during the week. No further questions. Well, that was easy. As you can see, once you have put the witness into a position where their testimony comes into doubt, you do not want to ask another question to allow him to clarify or provide an explanation. It is best to end the cross-examination and let the doubt linger or move on to a different line of questioning. Sometimes a great cross-examination isn't defined by the questions that you do ask, it's defined by the questions you keep yourself from asking. Questions related to underlying motivation or bias. Your cross-examination can also include questions about the witness's underlying motivation, such as Officer Davis's desire to strip search me, testifying on any basis that the witness may have in favor of the party or against you. For example, you could ask, isn't it true that you owe the other party money? Isn't it true that you're just out there to try to make money off of the public? Isn't it true isn't it your hope that he will forgive the loan if you testify for him today? Isn't it? See, that's the thing. I'm working against a judge who's a Blue Line supporter, and to prove that the cops have underlying means of trying to make money, well, he's a part of the whole money-making scheme. It's really crazy how I'm pitted against such prejudice. It is, and we just continue. Of course, a prejudiced judge never sees prejudice. And so you want to get on the other party's good side by testifying for him today? Isn't it true that I broke up with you in high school and you were so upset you promised to get back at me someday? So, what if my witness's credibility is damaged during cross-examination? Just like you like being cross-examined, the opposing party's witness will be less believable. The same thing may happen to your witnesses. If your witness's credibility is damaged, my star witness is Officer Miller, and is Prosecutor Benjamin gonna try to damage Officer Miller's testimony? That would be hilarious. For the prosecutor to try to damage the cop's testimony will be something amazing. On redirect, let's see. You can only ask questions related to the cross-examination. Using open-ended questions, you can ask for a witness to provide more detail and explain away any testimony that you believe was damaging. For instance, let's take the example given in the prior question where you cross-examine the opposing party's witness regarding the Blue Line bus. If the opposing party got a chance to redirect the witness, it might look like this. Opposing party, You testified on cross-examination that you took the blue bus line to the park on Saturday, but then you acknowledged that the blue bus line only runs on weekdays. Can you explain this inconsistency in your testimony? I got confused because I always take the blue line bus to the park, but I usually go on Friday. Now, I remember that I waited for the bus that Saturday and it never came, so I took an Uber. I have the proof on my phone, actually, of that Uber ride, and it shows the date and time. Keep the possibility of redirect in mind if your witness's testimony has been damaged by the other party's cross-examination. But don't ask for a redirect unless it is absolutely necessary. Redirect can open the door to recross, which could produce more damaging testimony. Also, judges often won't allow redirect in an effort to move trials along. Is there a process to admit evidence other than testimony? Every court is different, but generally there is a certain way that evidence is entered into the court record. Where am I at? I'm on the same spot I got arrested. Have the evidence marked, okay, Petitioner's Exhibit 1, so the court can keep track. This also helps if the case is appealed so that anyone reading the transcript knows what evidence is being referred. So, you should bring extra copies to give to the other party and to keep for yourself. During the trial, it is helpful to mark down notes for yourself about what number each piece of evidence is given so you can refer to it during the trial as needed. Then you will ask the judge if you can show the evidence to the witness. The judge may let you walk up to the witness, which is known as approaching the witness, or the judge may order the court officer to take the court officer to take the evidence from you and hand it to the witness. Once the witness has the evidence, you will have the witness describe what the evidence is and where it came from. Let me just get this straight. Ask the judge, can I show the video to the witness? And then I'll show the video. Once the witness has the evidence, that you will have the witness describe what the evidence is and where it came from in very basic terms. If you do not have a witness, you could describe and enter the evidence while you are testifying. For example, you could ask, what is Petitioner's Exhibit 1? It is a photograph showing a knife. Have you ever seen that knife before? Yes, it is the other party's knife. How do you know? The knife has a carving of a bear on the handle, and it has the other party's initials on the blade. I've seen it at his house and in his glove box. Is this a fair and accurate depiction of the video? I show the body cam, and then I ask, Officer Davis, is this a fair and accurate depiction of the body cam video? Asking if the photo is fair and accurate depiction is typical language that is used to show that the video accurately reflects the scene, which is known as authenticating the video. So fair and accurate depiction. I need to be reminded of that. Let's see. We got a witness does not have to be the one who took a photograph to be able to authenticate it. Although if the witness did take the photograph, you can ask about that. Well, this witness did take the body cam video, and yeah, you can use similar questions if you're trying to admit physical evidence, such as the actual knife. However, instead of asking if it is a fair and accurate depiction, then you could ask, is this the actual knife? Is this the actual body cam footage? Is this the actual body cam footage? Similarly, if you're trying to enter documents into evidence, your last question would be, has this document been altered in any way? For videos, you could ask the following question. Have you seen this body cam footage before? Yes, that is a compact disc. That is a video that I created of the altercation that I created. How do you know that? I took the original video on my body cam and then I transferred it to this disc. Alright, does a cop transfer that information? I labeled the body cam footage, and it's a series of numbers. It has a date on it. There's my handwriting on the disc. Was the video altered in any way? Okay, that's a question that needs to be asked. Was the video altered in any way? Hold on a second. Yeah. Okay. Is this a fair and accurate depiction? Okay. Accurate depiction of your body cam footage. Okay. Was this, and then was this video altered in any way? Okay. Alright, did I get this right? Stamy. Oh yeah, Stamy's a thick guy. Let's see, what do we got? Anything? Okay. So we got a couple questions to authenticate here. I have to authenticate with the cops. And I might be the one on cross-examination authenticating this, because I don't think the prosecutor is going to bring the video up. And if they do, great, then it's up. Does the video show a clear and accurate depiction of what occurred between you and the other party? Okay, okay. Is it fair? Maybe that would be a good question. I'm going to ask that one too. Does the video, let me just lay the foundation? Does the video show a clear and accurate depiction of what occurred between you and other? Okay. Oh. Okay, after you have laid the foundation, you gotta lay the foundation for the evidence. You can ask the judge if it could be admitted into evidence. Okay, I gotta write that down too. Ask judge into evidence. Okay. Into the other party can object, and being admitted, the other party could also ask the witness additional questions about the evidence before deciding whether to object to the evidence or not. These questions are called voir dire. Really? Let me just... I thought that was only for... I thought what voir dire was for the jury. Keep in mind, when the other party is trying to admit evidence, you can also object or ask voir dire questions. If the judge accepts the evidence, it will be marked as admitted. Really? And you are free to ask questions about it with any of the people who are testifying. The judge will usually keep the evidence in the court, so if you're trying to admit something from your cell phone or another item that you need back, it is best to bring in printed screenshots or photographs if possible. Objecting to evidence. Be ready to object to questions asked by Prosecutor Benjamin. What is an objection? An objection is how you tell the judge that the other person's evidence, testimony, or question shouldn't be allowed. You can object to the entry of any form of evidence as long as your objection is based on the rules of evidence in your jurisdiction. Okay, the rules of evidence in your jurisdiction. What does that mean? Why would I want to object to evidence? Alright. Once evidence is given to the judge, it is part of the official court record, and the judge can consider it when deciding your case. A successful objection will keep evidence from entering the record. This means the judge or jury cannot use that evidence to decide your case. You would want to object to evidence if it harms your case, and there is a rule of evidence that says the evidence should not be allowed. Here's a couple more reasons why it is important to object to evidence. Making an objection at the time the evidence is admitted and including the reason why you are objecting can be important if you later decide to appeal the case. Anytime you object, the judge might disagree and allow the evidence into the record. If you lose your case and the evidence was allowed in, it was important to the case, then you might be able to appeal based on the judge's decision to allow in the evidence. However, if you did not object to the evidence when it was entered, then you may not be able to appeal based on that issue because you failed to preserve the objection in the record. Even if the evidence should not have been allowed in, please see our filing and appeals page for more information. So do I object to the videos? I want the videos, right? Please see our filing, okay, that you're trying to have admitted and the judge allows sustained and the objection and doesn't admit the evidence. It is important for you to object to the exclusion of the evidence and explain why the evidence was both relevant and important to your case. This is called making a proffer. While sometimes it can be difficult to ask the judge to allow you to tell her the reasons your evidence should be admitted, if you don't, you may not be able to appeal your case based on the judge's improper exclusion of it helps to anticipate what evidence The other side likely will try to have excluded and practice your argument as to why the evidence should be allowed. Sometimes if your witness is having difficulties while testifying under cross-examination, you may want to object to a question to disrupt the flow of questioning. This can give your witness a chance to regroup and hopefully answer the following questions better. This tactic should be used sparingly, however, because it can backfire if the judge thinks you are only objecting to be disruptive. You must have a valid basis to object, like if the question has been asked and answered, or if the other attorney is badgering the witness. Every time you object, make sure you have a reason for the objection and you are prepared to explain it. Make sure that you only object when it is needed. Objecting too often to evidence without a valid reason can make it more difficult for you when you do make a valid objection. The judge may not take any of your objections seriously, and you may find yourself in a boy who cried wolf situation. Too many objections might also affect your rapport with the judge or jury. What steps do I need to take during the trial to set myself up for possibly being able to appeal? Let's see. I see ICBM stood out here. Your internet lawyers are hilarious, like a bunch of little kids playing court. Your childish YouTube act is a joke, just whipping up drama so you can post video of yourself doing it. Alright, well, and the cops have not created any kind of drama. They haven't been any kind of, I don't know, any kind of players in their agenda. Although it may seem odd to start preparing for the possibility of filing an appeal while the trial is, it may seem odd to start preparing for the possibility of filing an appeal while the trial is still going on. And I actually just filed a couple pieces of paperwork to send to the county clerks today, so they'll see it on Monday. You will only be able to appeal and adjust trial ruling if you take steps during the trial to make a record. Alright, demonstrate your ground for appeal. Here are the most important things you need to know and do during the trial. Make timely objections to any mistakes. You will need to object to any mistakes the trial court judge makes, and they make them. That's the thing. Like, judges make mistakes, and I have to be able to point that out as they happen so that the judge knows that you believe a mistake was made and has an opportunity to possibly correct that mistake. Making timely objections is called preserving your record. If you file an appeal, the appellate court will only be looking at the record, which includes all the documents from the trial litigation, as well as the transcript of what was said during the trial, including any objections made. The appellate court will usually only consider those mistakes that you preserved in this way. Anticipate and prepare for rulings on evidence. Often the need to object during the trial will be in connection with evidence you want the judge to allow or evidence proposed by the opposing party that you want the judge to keep out. It is important to prepare in advance your arguments in support of your evidence, as well as to think through possible challenges to any evidence that the other side is likely to try to admit. As part of that preparation, think about the possible need to make a proffer. A proffer is an argument you make after the judge has refused to admit a certain piece of evidence that you need to politely ask the judge for the opportunity to make a proffer as to why your evidence should have been admitted. For example, if the judge refuses to allow you to submit body cam video because they were sent badly, your proffer could be that the body cam video should have been admitted to show the long history of misbehavior. It shows a history of misbehavior. Know and ask for what you want. Make sure to ask the judge for everything that you want as a result of the trial, and be prepared to explain the reasons for your request. For example, if you're asking for a protection order, but you also fear for your child's safety, be sure to ask for your kids to be included as additional. Okay, whatever. Make requests. Closing argument will be especially important if you have not had a chance to ask for what you want by the end of the trial. If the judge doesn't ask if the parties want to make closing arguments, politely speak up and ask if you can do so. If the judge refuses, politely explain why you were hoping to make a closing argument. Well, I was hoping to make a closing argument. Post-trial motion as a possible last resort. If you feel you did not have the opportunity to fully present your case, or if the judge rules against you for a reason that you couldn't address during trial, it may be worth filing a post-trial motion, such as a motion for reconsideration or a motion to stay. And let me just add that I'm still in limbo with my motion to dismiss, my motion to suppress evidence. They're called premature pretrial motions. And now we're looking at pretty much post-trial motions. The judge is treating pretrial motions as post-trial motions, but then when it's post-trial, different kind of motions come into play. The motion for reconsideration and the motion to stay. Those don't look like motion to suppress evidence or motion to dismiss case. So he wants to lump pretrial motions in with post-trial motions all together, and I don't know. It just doesn't sound right to me. I've never seen that before. How do I make an objection? The rules of evidence guide what kind of objections you can make to object. If you have to say objection as soon as you hear statement in testimony or a question posed to a witness that is objectionable, you can stand up if you need help getting the judge's attention. Or how about holding up a sign? You can object to an answer that a witness is giving, and you can also object to a question from. You can object to an answer, and you can object to the question if the question violates a rule of evidence. If the other party is presenting physical evidence, which could be body cam video, you can object any time before the judge admits the evidence into record. The judge might ask you what the basis is for your objection. You should be prepared to tell the judge why it is that you are objecting based on the rules of evidence. After you make an objection, the judge then decides whether the objection should be sustained, which means that evidence should be not considered, overruled, which means the evidence can be considered. What are some common objections? Here are some common reasons for objection, which may appear in your state's rules of evidence. You can object to the relevance of evidence if you think a piece of evidence or something a witness is saying has nothing to do with the case, or it is not important in determining who should win in court. Example, how many sexual partners someone has had wouldn't be relevant in a protective order. Unfair, prejudicial. My case is more prejudicial than it is probative. You can object to evidence even if it's relevant, if the evidence would unfairly turn the judge against you. So even if it's relevant, you want to object to evidence that the testimony from the cops when they're lying, I think. Objection to their lying. That is what is meant by saying the evidence is prejudicial. Evidence that one of the parties has been in jail before may be relevant, but the evidence may also be unfairly prejudicial if it paints the party in a bad light to the jury. Like, they're going to argue that I've been in other states getting arrested, so I have to object to that and say it's unfair, prejudicial. Whoops, come on. Unfair, prejudicial. I can object to if they're going to bring up that I've been in jail in other states, I'll object and say it's unfair and it's prejudicial. How about leading questions? If the other party poses a question on direct examination that leads the witness to a certain answer, you can object to the question. Then you could object to the question as leading. This is usually the case with yes or no questions. Keep in mind that the judge might allow some leading questions during direct examination for simple background information to move the testimony along faster. For example, let's say the other party's mother is testifying. The judge might allow the question, "You are the respondent's mother, correct?" That's the leading question. Instead of, "How do you know the respondent?" However, when someone is asking about issues that directly relate to the case, leading a witness is not allowed. On direct examination, this leading question could be objected to. The car that you saw leave the scene of a robbery was blue, right? Objection, leading. Instead, it should be asked, what color was the car that you saw leaving the scene of the robbery? Compound question. A compound question is when two or more questions are combined as one question. Compound questions are not allowed because they can confuse the witness, the judge, and the jury. Also, it may not be clear for the court record which of the questions the witness is answering. If you find yourself asking a compound question, don't get flustered with the other party's objection and skip the issue entirely. Just separate out the questions. Ask them one at a time, and they might be allowed. Example, why did you go back into the house, and what made you think it was a good idea to then take the children away? Argumentative. When the person asking Cross-examination questions begins to argue with the witness, known as badgering the witness. Then the other party can object to the question as argumentative. Example, opposing party's attorney, you are not afraid of my clients, correct? Opposing party's attorney, oh come on. How can you be afraid of a guy who weighs 120 pounds when you weigh 300? I am afraid of him no matter what his weight. Well, you didn't look very afraid to me when you walked into court today. Objection, Your Honor, argumentative. That's a good one. Asked and answered. Sometimes during cross-examination, the person asking questions might ask the same question over and over again, perhaps in slightly different ways, or re-ask a question they had asked earlier in the testimony. What's unique about this objection is that it could come up in two different scenarios. First, opposing counsel could repeatedly ask you or your witness the same question, hoping that contradicting answers will be given. Second, opposing counsel could repeatedly ask their own client the same question in slightly different ways, hoping that the client will give a better answer than one given before. Either way, a question can only be asked once, and after it has been answered, any further attempts to ask the question are objectionable. Example, other party, do you remember when I wrote you a check for $10,000? You know that never happened. You're saying that I didn't write you a check for $10,000? No, you didn't. I'm talking about last year. You remember the check I wrote for you, right? Objection, asked and answered. Vague. A vague question is when it is difficult or impossible to tell what the question is about. You would want to object to a vague question that is asked of your witness because of the risk that the witness will misunderstand the question and say something that will hurt your case. If the question is objected to, the person asking the question might then be able to ask this question in a different way that makes more sense or is more specific. Example, let's say the opposing party asked, can you tell the court where you went earlier? Earlier is not specific enough, it's vague. After an objection, the question could be rephrased. Can you tell the court where you went this morning right before you came to court? In addition, the question that refers to this or that might be too vague if there is no context as to what this or that refers to. So don't be vague. Don't be a vague person. Foundation issues. A question or response can be objectionable if a person failed to explain the background of how they know the information they're testifying about or are being asked about. When answering about specific facts, the witness has to set the stage and explain how they know the information that they know. Example, a person can't testify that it was a certain person's voice on the phone without explaining that they had spoken with a person many times over the last few years and the call came from the same number. Foundation. Non-responsive. When a witness starts responding to a question with the information that is completely unrelated to the question, you can object to it as being non-responsive. This can be especially important in cross-examination when you're looking for very, very specific yes or no answers. Let's see here. Example, isn't it true that you put your hands around my neck after you pushed me to the ground? Well, yes, I did. When I broke free, isn't that how you got the bruises on your arms? Look, I didn't mean to hurt you, I was just trying to get your attention. Objection, the answer is non-responsive. Oh, the answer is non-responsive. This is for the answer person. So, non-responsive is for the witness. They must answer the question. In addition, sometimes when a witness is being questioned on direct examination, they will make an effort to explain away a bad answer during the next question, regardless of what the question asked is. This is another instance when you could object to a non-responsive answer. Example. Yep, that's true, Stanley. If I repeat the same activity every day and nobody's calling the police on me. When is your next visit scheduled for? The reason I only saw them once last month is because their mother likes to play games and hang the children over my head. Objection. The speculation objection can be used in two different situations. First, if a witness does not know a fact to be true or not, but testifies about it anyway. This testimony would be speculation. 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 The speculation objection can be used in two different situations. First, if a witness does not know a fact to be true or not, but testifies about it anyway, this testimony would be objectionable as speculation. A witness must have personal knowledge of a fact to testify about that fact and put it into the court record. For example, and that's why all of you people in the chat specifically the prosecutor would object that you can only speculate about what happened, even though you saw it clearly on video. You guys are all just speculators to the city, just speculators. So the person leave the house. Valid for some beliefs. Is there no? Oh, we got what? Yeah, we got a mod. Second, if a question that is posed can only be answered by using speculation, the question would be objectionable. What do you think your sister was thinking when she left? Objection, Your Honor. The question calls for speculation. All right. Opinion. If a witness testifies if a witness testifies about an opinion, they have that as a technical in nature and not based on facts, the witness has first-hand knowledge of, then you may be able to object based on it being their opinion. Generally, only a witness who has been recognized as an expert witness by the judge can offer an opinion. Example, an abuser cannot testify that you are crazy. They can testify about behaviors that might have witnessed that they find concerning. However, any testimony that might suggest some sort of diagnosis would usually be objectionable as opinion. However, you could not testify definitively that the substance you found in the abuser's glove box was a drug, unless it was tested by the lab or the abuser admitted it. You could testify that you saw a white powdery substance in a bag that appeared to be, based on your understanding of the drug and what you looked up online. However, a judge may allow testimony such as, I am a good mother. He is a good father, even though that is opinion. Whoops. Hearsay. A person can only testify as to what they know to be true, not what they heard from someone else. Just a second, let me just, okay. If a witness tries to testify about what a non-party told him, or tries to enter into evidence something in writing that a non-party wrote, then the testimony or written evidence is objectionable as hearsay. However, there are hearsay exceptions that may apply. Hearsay is defined as an out-of-court statement admitted for the truth of the matter asserted. To understand what hearsay means, we'll break down each part of the definition. A statement can be what someone said out loud, or a statement might also be a written or typed on a document, like a letter, an email, a text, okay, or some other kind of record. Let's just a second. Alright. Out of court means simply that the statement being entered into evidence, either through testimony or written, was said or created outside of the courtroom and not during the trial. Admitted means given or entered into the court. So in most cases, it is evidence or testimony that a party is giving to the court for the judge to consider when they make a decision about the case. For the truth of the matter asserted means that the evidence or testimony is being presented to the court as proof of the fact contained in the statement. So in other words, you want the judge to believe that whatever you testify that someone else said to you, or what you show the judge that someone else wrote, is true, and you want the judge to rely on that information. Whether or not you are offering a statement to the judge for the truth of the matter can depend on the context of the case. The same statement could be offered for two different reasons, and one reason may not be hearsay. For example, if a witness testifies, he said, "The weather sure is great today." This might not be hearsay, as is admitted just to show that someone said those words to the witness when they met. In other words, if the witness wants to show that this is how he greeted her, however, if the weather on a certain day is a major issue, and the witness says, he said the weather sure is great today, as a way to prove that the weather was in fact great, then a statement like this would be hearsay. Let's look at some examples of how to spot hearsay within the different types of evidence. In testimony, in most instances, if a question, just a second here. Geez. We don't have, I'm looking for some vital information. I guess I could look up on, there it is, okay, alright. In testimony, in most instances, if a question asks for what a person said, or when a witness begins a statement by saying she said or he said, you'll probably be able to object. Okay, so just listen for she said or he said. And there you go. Objection, hearsay. Questions that call for hearsay are objectionable. What did he say to you? Can you tell me what oh, wait a second. Let me get this right. What did he say to you? Objection, hearsay. Can you tell me what the letter said? Objection, hearsay. Testimony about what someone else said is hearsay. His sister told me that he has guns under his bed. Objection, hearsay. My doctor said that I have a concussion. Objection, hearsay. The teacher pulled me aside and said Johnny has been hitting other students. Objection, hearsay. Remember, sometimes a witness might be saying what the other person said just to show that the other person said something, anything, if the content of what was said does not matter for the court case, then it is possible that the statement is not admitted for the matter asserted, and therefore it is not hearsay. Said something, the context. If it doesn't matter for the court case? Alright, testimony that is not trying to prove a fact about a case is not hearsay. The officer said to stay calm. That's not hearsay. In documents, who cares? I don't see video in them documents. No videos. Police report, maybe. Technically contains statements that are hearsay and could be excluded. Gotta proofread them police reports for hearsay. If you plan to admit a document like one listed here into evidence, you should look through the hearsay exceptions and think about which would apply in your situation. The other side might not object to the documents, or the hearsay rules might be more relaxed in the court you are in, and they will certainly, because everything seems to be relaxed, but there's their arrest standards. They lower the arrest standards. They raise our offender standards. When would I object to specific kinds of evidence? The kind of evidence that the other party is trying to give the judge will affect when and how you make an objection. Normally, an objection is made by simply saying, I object, or objection. I object to specific kinds of evidence. If the reason for the objection is obvious, then the judge may make a ruling without making you explain why you're objecting. If the reason for your objection is not obvious, you should be prepared to explain the reason why you're objecting. Testimonial evidence. You can object at any point while the witness is testifying. This can be during or after a question. While the witness answers the question, or immediately after the witness finishes answering, but before the next question is asked. You can object during or after the question if the question itself is objectionable, or if it calls for an answer that is objectionable. For example, the direct examination question is leading. A question calls for hearsay, or the witness does not have personal knowledge of what is being asked. The question calls for speculation. You may object while the witness answers the question or after the answer is complete. If the answer itself is not objectionable, but while answering it, the witness says something that is objectionable. For example, the witness has mentioned that they heard from someone who heard from someone that something happened. This kind of response is most likely hearsay, and you can interrupt the witness to object while the witness is answering, or object immediately after the witness finishes answering. Now, if there is a jury, you should try to object as quickly as possible so that the jury doesn't hear any objectionable testimony that they would have to try to forget. Documentary or physical evidence. Parties have to go through a process to enter documentary or physical evidence into the court record. During that process, the party that is entering the evidence will show the documents to the other party so that they can examine the documents. At this point, you can object to the evidence by saying objection and explaining why you feel the evidence should be kept out of the record. If you don't have a reason to object at the moment that the evidence is first shown to you, it's possible that you may come up with a reason to object after the witness is questioned about the evidence. The party entering the evidence may ask the judge for permission to enter the evidence into the record, or may offer the document marked for identification as Exhibit A into evidence. This is another opportunity for you to object to the evidence. At this point, the judge might ask if you have any objections to the item being entered into evidence, but if the judge doesn't ask, you can still object. Be prepared to explain why the evidence should or should not be admitted. Demonstrative evidence. Okay, I'm not really dealing with that. I do have some screenshots, but diagrams, slideshows. I guess I reached the bottom. I reached the bottom. Keep in mind. Okay. Let's see what it looks like if I do this. I'm gonna make it wider. Okay, let me just bring this. Oh, come on. Alright. So now it's off screen a little bit more. and over. Alright, so I guess I've pretty much, whoa, I made it a little too wide. I guess that's it for the training. It's not a huge amount of training. The biggest thing is that my freedom's on the line. That's the most concerning part. I mean, there's quite a bit to learn, but I'm pretty familiar with a lot of it. It's just stuff I haven't put into practice. Alright, the Fourth Amendment protects the privacy of citizens unless they have a serious crime that the cops need to investigate. And common activities are not serious crimes. I don't know. What else? I guess I just wanted to go over this training. And so since it should also be illegal to strip search people. Where's the description about my strip search? Alright. I guess I could probably just call it quits then, since I've reached the bottom. I just continue on looking at other stuff. I just wanted to go over this with by speaking it out loud. So I guess this is gonna be it. I'm gonna just stop this stream for now. I don't have anything else to say. Thanks for